In every contract of sale, the law does not only concern what is sold, but how it's sold. Articles 1594 to 1599 of the Civil Code lay down the essential duties of the seller: to deliver, to ensure rightful ownership, and to guarantee that what is sold is exactly as promised. These aren't just obligations, they're safeguards of trust in every transaction.
Today, let's explain Article 1594 of the Civil Code, which introduces legal available remedies in cases of breach of contract of sales of goods. Under this article, action for breaches are governed primarily by specific rules of Chapter 6. It is important to note that this rules only applies to goods, which includes personal or movable property such as vehicle, machines, or crafts. So let's break them down into two sides: the seller's right and the buyer's right. If the seller is the one who is aggrieved, they may file first an action for payment of the price if the buyer refuses to pay the delivered goods. Second, an action for damages if the buyer refuses to accept the goods. And third, an action to rescind the contract if the buyer is seriously breaches their obligation. On the other hand, if the buyer is the one who is aggrieved, they may file first an action to specific performance to compel the seller to deliver the goods, or an action to rescission or damages, particularly if the goods don't meet the warranty or contract terms. In short, Article 1594 is a well-structured set of remedies giving both the seller and the buyer a clear legal option when the thing goes wrong in a sales of goods. It ensures accountability, fairness, and protection so that they are encouraged to honor their obligation or to fulfill their obligations. So let's analyze this scenario. One sells 200 sacks of rice to Alexis for 300,000 pesos. They agree that Alexis will pay upon the delivery. One delivered the rice to Alexis, but Alexis refuses to pay without any valid reason. So what could be the possible action or solution for this case? One can now file an action for the payment of the price since the rice was delivered. Or if Alexis refuses to accept the rice, one can instead sue her for the damages for non-acceptance. Since this article ensures that when a contract to sell goods is broken, the seller and the buyer have specific legal remedies under this article. In this case, since Alexis broke the promise to pay, one can go to the court and demand payment or take other legal or proper action based on this situation.
Proceed now to Article 1595 of the Civil Code, which gives the right to a seller to sue for the price of goods when it's already transferred or the ownership has been transferred already to the buyer. So this article also shows that it is effective when the buyer neglects to pay the seller or due to incompetence of the buyer. So, for example, Anna already produces 50 pieces of bond paper ordered by Carmila. So, Anna already delivered the 50 pieces to Carmila, and then when the bond paper was already been received by Carmila, Carmila is still not yet giving the payment or she refuses to give payment on time. So take note that there is a specific date also that may be included in the contract, specifically if that is in a form of contract. So the buyer must be responsible enough to pay, especially when the ownership was been transferred already. So you as the buyer should know that as the receiver, you must also be the sender after the transaction has been fulfilled by the seller. So when you refuses to pay, obviously the seller has the right to sue you as someone because you are irresponsible, you neglect to do your obligation or to do your part as the buyer. So that's how Article 1595 works. So it is between the sellers and the buyers' obligations in each part. It's about it's about reciprocal ways that a buyer should pay the seller, or should give money, should pay, of course, because she received or he received the goods or the ownership already. So yeah, as the seller, you have the right to sue the buyer, basically because you are responsible enough to fulfill your duty as the seller, then it should be done vice versa. So that's it.
In Article 1596, if the buyer refuses to accept and pay for the goods, the seller can sue the buyer for the damages for the non-acceptance. And the damages is based on the estimated loss directly and naturally resulting from the buyer's breach. Example, you agreed to make 20 cookies to be picked up by the buyer by Monday, but the buyer refuses to pay and accept the goods. Now, you don't have any choice but to rush the selling of the cookies, and the selling price is below the original selling price. Therefore, you can sue the buyer for the amount of loss incurred. There's a market available for the goods, and then the damages are computed by finding the difference between the contract price and the market price. Um, Similar to our example earlier, if the seller already spent the effort, labor or materials to fulfill the contract, and then the buyer suddenly cancels, then she or he must pay for the labor already done, for the expenses already made, plus consider the profit that the seller would have been earned if the sale had been completed.
Article 1597. Seller's right to cancel a sale before delivery. What it is about. This article explains when a seller can cancel a contract for goods that haven't been delivered yet. It focuses on situations where the buyer has broken their part of the agreement. So, there are things that we also need to consider here. First is seller's option. If the buyer does not any of the following things before the seller delivers the goods, the seller can cancel the sale by giving notice to the buyer. First is repudiates the contract. The buyer clearly says they won't go through with the deal. Second, shows they can perform. The buyer demonstrates they are unable to fulfill their obligations, like paying. The third one is breaches the contract. The buyer breaks the terms of the agreement in some other way. Notice is required. The seller must formally inform the buyer of their decision to cancel the contract. This notice doesn't have to be overly formal. A clear indication of the seller's intention to rescind is sufficient. Starting a lawsuit to get back what the seller gave is also considered sufficient notice. No absolute right. The seller's right to cancel isn't absolute. The law considers factors like whether a third party is now involved who is not at fault. Also, canceling the contract is usually only justified when the buyer's breach is significant, not just minor. For example, imagine you order the custom-made guitar. Before the guitar maker finishes it, you tell them you've changed your mind and won't pay. The guitar maker can cancel the order and keep any materials or labor they've already used. They would need to notify you of this decision.
So now let's talk about the Article 1598, and it's all about the buyer's right to specific performance. So, when the seller refuses to deliver specific goods that were agreed upon, the buyer has the right to demand specific performance. Meaning, the seller must deliver those exact goods. The seller can't escape by just paying money to the damages. So, the court can require the contract to be fulfilled and may add fair condition like payment timing or additional damages. This rule protects the buyer's right to get what was promised, especially when the goods are unique or hard to replace. So example, you buy a specific diamond ring from someone, like for me, but I refuse to deliver it and offers money instead. But you can go to court and force me to deliver the ring, not just pay damages. And that's all about Article 1598.
Let's dive into Article 1599, which deals with what a buyer can do when a seller breaks a warranty. A warranty is basically a promise saying that the goods is certain of quality and that the sellers legally own them. Law gives four different choices to a buyer. First, keep the goods and reduce the price. Keep the goods and sue for damages. Reject the goods and sue for damages. Cancel the sales, return the goods to get refund. But remember, you can only pick one of these remedies. You can't mix and match. However, if the first choice doesn't work out, for example, you sue and can't collect, you might be allowed to shift into rescission under Article 1191. The buyer can cancel sale if the buyer knows the defect and accepted it without protest, or they didn't tell the seller about the issue on a reasonable time, or they can't return the goods in almost same condition unless the damage was caused by the defect itself. For example, a coffee owner wants to decorate their shop and buy 40 wall clocks that shape like a coffee cups worth of 40,000 pesos. The clock's supposed to be functional and decorative, but when they arrive, 8 of them doesn't work. Now, instead of sending them all back and start a full-blown complaint, the owners decides to take everything and tell the seller that 8 of 8 of this is useless for telling time and I won't pay full price. Now, the worth of 8 clocks is 16,000 pesos. The buyer deducts that to the total price and only pays 24,000 pesos for the 12 actual working clocks.
From delivery to hidden defects, the seller's role doesn't end at payment. Articles 1594 to 1599 remind us that in every sale, responsibility continues after the deal. Because in law and in life, what's promised must be fulfilled.